May I proceed?
You may.
May it please the court. He could have folded, but instead, he went all in. Last spring, 2014, the Midlands Gambling Commission announced that it'd be issuing a new license for a casino. Now this is a big deal in Midlands, as these gambling licenses are given out only once every decade. In the spring of this year, the commission began taking in those proposals. They received proposals from many entrepreneurs like J.C. Longstreet, Avery Bancroft, the defendant in today's case. At the same time, the Midland State Police Department was involved in an investigation in the Gambling Commission into alleged corruption. It was within this investigation that the state police captured Avery Bancroft, the defendant, in his plot to bribe Chase Covington, the chairwoman of the Midlands Gambling Commission, in exchange for a second gambling license, making Avery Bancroft the first person in Midlands to own not one, but two casinos. We as the prosecution in today's case cannot simply make these allegations, we have to prove them to you. When the state walked into this courtroom, we walked in with a legal burden. We have to prove, beyond a reasonable doubt, that the defendant, Avery Bancroft, bribed Chase Covington of his own free will. In order to meet this burden, we have two prongs laid out for us by the law. First, we must show that the defendant was predisposed towards bribery, and second, we must show that inducement did not occur. In essence, the prosecution has to show that Avery Bancroft made this bribe of his own free will and that he was not entrapped into doing so by the state's presence in their investigation in the Gambling Commission. Do not be confused, members of the jury. We're not here to determine whether or not a bribe occurred because the defense has already admitted that the bribe happened. We are simply here to determine whether or not something called entrapment was present. Now, what entrapment means is that the state's law enforcement caused a crime to occur where it otherwise wouldn't have happened. And that's what you will be focusing on in your deliberations at the end of today's trial. In order to prove our case to you, the state will call forward three witnesses. First, Corey Hyde. Mr. Corey Hyde was the defendant's executive assistant, helped put together the proposal for the casino, and set up all the pertinent meetings between Avery Bancroft, Chase Covington, the chairwoman of the Midlands Gambling Commission, and Officer Mickey Keenan, who was working undercover within the Midlands Gambling Commission in order to catch the defendant in his plot to bribe Chase Covington. Next, we will call Danny Hoy. Mr. Hoy was the head of security at the Black Bear Casino, the defendant's casino, and will explain the lapses in video surveillance on the casino floor. As you will hear, the defendant used these lapses in video surveillance to meet with Chase Covington in a security blind spot in the VIP room of the Black Bear Casino, and finally go all in with his bribery scheme. Finally, we will call Dr. Reese Warren. Dr. Warren is an expert in something called forensic linguistics. His job is to analyze how conversational strategies can affect an individual's behavior. Now, Dr. Warren was initially contacted by the defense, but as you will hear in today's trial, he's being called by the state because of his conclusions. As you will hear, Dr. Warren concluded that there's not enough evidence to show entrapment occurred in this case, which means that if there is not enough evidence for entrapment to have occurred, then the defense will have failed to meet their burden laid out by their affirmative defense of entrapment. And it means that you will have no other option but to find the defendant, Avery Bancroft, guilty of bribery. At the end of today's trial, my co-counsel, Haley Gold, will come before you. She will tie together the elements of today's case, and she will leave you with the only reasonable answer: to find the defendant, Avery Bancroft, guilty of bribery, because he could have folded at any time, but instead, he chose to go all in. Find him guilty. Thank you.
Thank you, counsel. Defense, do you have an opening statement?
Yes, Your Honor. May I proceed?
You certainly may.
Jonathan McCarriage for the defense. May it please the court.